Welcome to our channel, Card Ventures NG, Obata Chamber. I'm your usual host, John Choka Obata, an attorney. And as usual, my senior partner, Paul Machuku Obata. We are planning and environmental lawyers and property consultants. Every country has its own general planning law, and how well planned a city or town is depends on the adequacy, effectiveness, monitoring, and enforcement of physical planning laws and regulations. Generally, it is up to a local planning authority to decide whether to allow a particular development or not. The concept of zoning indicates which areas can be used for what development. In this episode, we shall be focusing on the concept of planning, zoning, and planning laws. Judicial interpretation of Section 20 of the 1999 Constitution in Attorney General of Lagos State versus Attorney General of the Federation and others, 2003. The judgment posited that the environmental objectives in Section 20 of the 1999 Constitution is to protect the external surroundings of the people and ensure that they live in a safe and secure atmosphere, free from any danger to their health and other conveniences. And that the National Assembly is not given the power to legislate on planning and development cover over land in the states and local governments. Let's go right in for more insights.
And come to it, you can see that we are seeing a different facet of conservation here. And so conservation here is extended. Yes, there is an extension of the meaning of conservation in planning law. And so it is extended to include the enforcement of Housing Act. You know, there is the Housing Act of 1949. The Housing Act of 1949, which provided for urban housing rehabilitation and the conservation of existing housing for existing housing. That is the conservation of high standard areas. Conservation of high standard areas. And so conservation here is the measure applied to non-slum areas. Non-slum areas or houses or structures that have standards and above standard qualities. Standards and above standard qualities. And so conservation measures prevent deterioration to below standards. Deterioration to below standards. In the urban centers or in the cities, the law has made provision that those houses, especially those along the express ways or along the roads, the arterial and the connector roads, you see some of these distributor roads, you see the houses in these areas are expected to comply with the planning regulations in respect of conservation. The houses, for instance, when they need to be rehabilitated, you know, or to be renovated, you know, they have to comply with the provision that they don't deface the aesthetics of the urban center. Yes, that they don't deface the aesthetics of the urban center. You can see where law has so much roles to play in this respect. Therefore, we see that let's come back to the three layers of permits. Remember, I earlier mentioned about the three layers of permit. One being the governor's consent in respect of the Land Use Act provision, and the environmental permit, that is in respect of the Environmental Impact Assessment Act of 2004, and the Nigerian Urban and Regional Planning Decree Board Edit of 1998. So you see, the provisions of these boards, you can see there are two layers of impact assessment, which is one, the NURP decree has made provision for environmental impact analysis, and then the Environmental Impact Assessment Act of 2004 has made provision for environmental impact assessments. And then we are going to see as we go on how the environmental impact analysis differ from the Environmental Impact Assessment Act. And though they are one, they are together, they work together towards achieving the goal of environmental conservation and protection of the environment. And then we looking at these three layers of permit, as I made under the physical planning law, the prospective developer or the house owner is under obligation to obtain layers of approvals from the government. And the first one under the Land Use Act is for the right of occupancy. The right of occupancy. And remember the saying in that quid plantator solo said it. Quid plantator solo said it. Whatever is affixed to the soil belongs to the soil. And so that is where the Land Use Act comes in this matter for the developer, because the developer wants to develop land. And so that consent is inevitable. And so that first one, which is for the right of occupancy under the Land Use Act, the Land Use Act vests the ownership, management, and control of land in each state and in the urban area on the governor of the state. For the Federal Capital Territory, it is vested on the minister. And then you see that the land is therefore allocated with his authority. Hence the need for quality and clean title to land. Yes, the need for quality and clean title to land, so that you may not be denied the consent under the Land Use Act. In these three layers, you know, in the three layers, it's expected that you have the first layer approved, the second layer approved, and the third layer approved, so as to be free as a private developer. And now coming to the second, that is the National Urban and Regional Planning Decree of 1992. Yes, the Urban Planning and Regional Decree of 1992, as amended by the Nigerian Urban and the Regional Planning Board Edict of 1998. And the aim of this act is to oversee a realistic and purposeful planning of the country to avoid overcrowding and poor environmental conditions. So the Nigerian Urban and Regional Planning Board, the Edict number 2 of 1998, states in section 38, subsection 1, that a developer shall, at the time of submitting his application for development, submit a detailed environmental impact assessment report. And then in section 3, subsection 1 to 3 of the Town and the Country Planning, that is the Building Plan Regulation of 1986, there is a requirement there that an application submitted in respect of any development where land area of 4 hectares and above, that for such application it must be accompanied with environmental impact analysis report, giving details of the effects of the proposed development on socio-economic environment, on traffic, ecology, and the communication network. And so, the following section also becomes instructive. Section 30, subsection 3. Building plan should be drawn by a registered architect or a town planner. That's the provision. Yes, but for the Lagos State Planning Board, there is an inclusion of a registered draftsman. And then other instructive sections there too includes section 39, subsection 7, which establishes that application or applicants would be rejected if development would harm the environment or constitute a nuisance to the community or not being in conformity with the development plan of the area. Then another section that is instructive is section 59 of that NORP decree, which makes it an offense to disobey a stop work order with fines for both individuals and company. And then section 72, which provides for the preservation and planting of trees and environmental conservation. Yes, environmental conservation. You know, that is encouraging developing with nature. You know, there is this act of individuals and people clearing everything on land, you know, before in the process of erecting a building, all the trees, everything felled, you know. At least this provision for environmental friendly construction, you know, is for environmental friendly construction. And in some jurisdiction, you'll find there is a requirement that those submitted documents must be certified environment friendly, you know. That's another layer, yes, of environmental permit. The activity, that proposed activity, the proposed project should be certified as environment-friendly one. That is one of the requirements. And what should be put into consideration is all these, does your site plan have provision for some of the trees on ground? That is why it is a requirement in surveys. That there should be a topographic survey as part of the documents for the survey for the site plan, showing the position of the trees and the life support systems, on land, using under the concept of exact boundary. The surveys or the topographic survey is to show the features on site, on ground, the tree locations and their elevations, so as to be able to determine the extent of damage done to the environment due to the development action. And then, as we have seen this, let's look at the other layer of environmental impact assessment under the Environmental Impact Assessment Act of 2004. You see, it's an assessment of the potential impacts of development activity, whether it is positive or negative, in respect of public and private projects. And in this regards, there are categories of projects. We have about 3 categories of projects. And the category that a particular project belongs to determines the extent of requirement of the environmental impact assessment, whether it be partial or full EIA required. And this takes place during the screening exercise. The screening exercise will be able to portray or to show the extent of damage that will be done on the environment, and then we'll now append an appropriate environmental impact assessment to be carried out in order to obtain the environmental permit for a particular development. And looking at that, there are relevant sections, of the Act that are instructive. You find in Section 2, subsection 1, there is the requirement for assessment of the projects likely to have a significant negative impact on the environment. And then in Section 2, subsection 4, it requires an application in writing to the agency before embarking on such projects for assessment to determine approval. You see, and then this Section 13 establishes cases where environmental impact assessment is required. And so there are these 3 categories, as I earlier mentioned. And later we are going to look at that the nitty-gritty of that provision in a different episode. And we will be looking at the different categories and then the requirements for each category in a different episode under this. And then there is also the Section 60 is also instructive. That section creates a legal liability. It creates legal liabilities for contravention of any provision, any of these provisions. There is a legal liability, and we will be looking at that, also in the different episode. And so, apart from providing that planning permission is required for carrying out of any development on land, you see, there are also provisions that can changes in land in use, changes in use, change in use of land, also require planning permission. So it's not just only planning permission before starting a project. Change in use of land would also require planning permission. And in some jurisdictions, especially like in the Town and Country Planning Act 1990 of United Kingdom, you see some or some other jurisdictions in Nigeria, or in some areas of Nigeria and in Africa, as a whole, these provisions apply that that planning permission is required for a new project and also for a change in use of land. So all in all, a private developer may therefore find himself in a situation where consent under the Land Use Act is approved and the consent for development is refused. You remember I did mention the 3 layers of permits. Okay, so if the first one under the Land Use Act is approved, and then the environmental consent, under the EIA Act and the Nigerian Urban and Regional Planning Decree, if in that case the consent for development is refused, or for the planning, that is for the building plan, is refused because of non-compliance or non-conformity with the laid down rules and the regulations. And then all the environmental permit may be requiring an alternative site, or you have a no development option as a result of the application. You see, permits, require, it is required. In that instance, the developer, that developer is in a fixed, because he cannot, there is a problem. Yes, there's a problem. So the governor's consent, the environmental permit, and the building permit, the 3 go together. They go together. And in this regard, you see, there are also situations where some problems arise when consent is to be obtained for mobilization of estate finance through mortgage or bank loans, and then for these problems arise then, and so you need to be guided. You need to be guided to be able to scale through. That is why professionals like Carpenters NG Law, Opata Chambers, we are there to advise. We are there to help, and we expect also that that prospective developers understand these processes as explained, so as to be able to have their ways, unhindered, or to curb unnecessary delays in in achieving their respective dreams.